the merits to this court on the question of the scope of remedies, because of course that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts. And what's supposed to happen to prevent that?
So I'm very much looking forward to hearing what you thought about all this.
Yeah, I'll do big picture and small picture. Big picture, I mean, everybody that was in the chat, but some people have probably joined after. This was against the context, the backdrop of birthright citizenship, about whether the 14th Amendment says what it means what it says, or any president, including this one, can change it by executive order to only apply to, as they continue to say, Trump and John Sauer, our Solicitor General, only applies to former slaves. I'm like, this is such a losing argument. And that's the backdrop. Mm-hmm. The only issue that's teed up for this Supreme Court, but the reason it went on for two and a half hours mm-hmm. on a 45-minute argument is because there is at least 4 or 5 votes to give further guidance to lower courts about how and when they're supposed to use a nationwide injunction. There's a small subset that would prefer class action certification, but even they, on the right wing, understand that John Sauer's argument is that we'll fight them at the class action stage. We'll fight them at the national injunction stage. If it ever gets up to you, maybe we'll comply with what the Supreme Court says 3, 4, 5 years from now, 3, 4, 5 generations of babies from now. In the meantime, we've just created an entire group of citizenless children who are rejected by the country of their parents and are rejected by the United States. This is like Tom Hanks. Are they going to go live at the airport because they don't have a visa or a passport? They can't get out of it, and no federal funds are going to be used for them. We just created a bucket of babies that are being harmed. But it might have frustrated a lot of people in the chat. Like, why aren't we getting to the heart of the Constitution, 14th Amendment? Because they have a bigger issue here. Now, I think it's a good thing that the Supreme Court took birthright citizenship as the case to talk about nationwide injunctions and the standards, because it is so in stark relief there, right? The issues are so acute. How do you say that a baby in Arizona doesn't have the same rights as a baby in North Dakota or in New York? How could you possibly do that? And you found that was very, very frustrating. The justices, and there's lots of clips, we'll play them here on Midas Touch, including the killer clip from Ketanji Brown Jackson about this is the Catch Me If You Can administration, and Justice Kagan saying, you've lost every argument about the merits of this case. You're 0-4, and we think John Sarah, we think we're gonna win somewhere. Really? Because you haven't won anywhere. And the question is, as Amy Coney Barrett put it, why does it matter to you as a government whether we shove this through a class action procedural mechanism or we shove it through allowing an individual federal judge to enter an injunction? What does it matter to you? Because at the end, it's the same exact result. And isn't class action as a vehicle sort of awkward and doesn't quite get at the matter when it comes to constitutional violations? That's the academic fight that's going on up on that bench. And what people saw as, and I saw it in the chats, what people saw as, oh, she's mad at this advocate, that's not what you're watching. What you're watching is the justices want to talk to each other and they want to get their arguments out, and they do it through a number of ways. Sharp, insightful questions. But then when they get an advocate that they like or that they agree with their position, like Feigelbaum for New Jersey or Corcoran, they want them to get and make the arguments for them. And when they don't make them quick enough or they don't catch the softball, they get frustrated. No, that's not the point. You're missing my point. It's not the rule against them. It's they want to draw out the argument in speaking to the other side. What we're watching on the court, though, is the battle between those that were like in the executive branch and think like Kavanaugh, they should have unlimited power, Roberts served for the first Bush, Kavanaugh and Gorsuch for the second Bush. They all believe in some version of the imperial president, the unitary presidential model. And so that is also going on here. And then you got Gorsuch, who's like written books about universal injunction should be outlawed. So it's a weird group. The question is for you, Dina, where do you think, and then we'll go over buckets and percolation and the winter factors and all the things that came up in the chat. But where do you think, how do we count the 5 or 6 or 7? Where do you think they end up in this? And you can answer it by saying, why did they take this case? Why did they feel it was necessary to make a proclamation, a declaration from the bench about nationwide injunctions?
Well, it's really interesting because this may have been the worst case to take for the judge who wants to get rid of nationwide injunctions, because the whole argument is one judge is going to decide, federal law in this moment for the entire country. But in this case, it's actually not just one judge, right? It's three different circuits. It's quite a bit. And there isn't, as one of the justices, maybe Kagan or Sotomayor, pointed out, this is in fact maybe a perfect case for a nationwide injunction because there's no factual dispute and the precedent is really strong. So the merits are strong. So it's kind of an odd thing. It almost makes me wonder if some of the judges who wanted to keep nationwide injunctions were on board with it, because this is the worst case to get rid of nationwide injunctions. And I think we saw that with even the ones who are leaning against nationwide injunctions, or very much against it. Alito, Thomas, very much against it. Gorsuch, very much against it. Roberts against it. Kagan, even a little bit against it. But they all were, I would say, kind of like less skeptical of it because this is a bad case to overturn nationwide injunctions. And I thought that it was interesting. One of the things that they made about the back and forth you were just kind of alluding to about whether or not, their whole argument, Trump's whole argument is that nationwide injunctions should not be allowed by judges. It's an excessive power. And historically, we haven't used it. It's only been in this last decade or so. And I thought it was interesting that it was Kavanaugh and I very rarely ever agree with anything he has to say, who actually blamed it not for activist judges, but for excessive executive orders. He said, isn't the reason why we're seeing it lately because Congress hasn't gotten much done, so the president is trying to kind of do more in these executive orders and they're exceeding their power, which would be the argument for keeping nationwide injunctions. So this is an interesting argument, I thought, because it was like a really bad case for overturning it, even for those judges who want to overturn it. To hear Kavanaugh make an argument that it's not about judicial overreach here, it's actually about executive overreach, was startling. At the end of the day, if the Supreme Court decides to get rid of nationwide injunctions, they are limiting their own power. They do that at their own peril. This is why they have never taken this up, even when Biden asked them to take it up back in January. Because if they do that, they have a lot less protection. And we saw that in the oral arguments. This is why we saw that pushback.
It also turns on its head Supreme Court procedure. They may not like having been pressured by the United States Supreme Court, by the Trump administration with 13 emergency applications, which has actually gotten in the way of them finishing all of their opinions for the year. However, getting one nationwide injunction teed up to come to the Supreme Court on the merits of a case, and they can make a decision at the moment whether they're going to stay or not stay administratively, that issue, until, to paraphrase John Sauer's verbal tick, until it percolates through the lower courts. Percolation just is another way of saying, I used to say marination. It's just that it goes through all of the regular process and briefing and the lower appellate levels and maybe remands back to the trial court before it is prime to go up on a writ of certiorari, the main way. Now that the judgment is final, goes up to the Supreme Court for final review. That's where the Supreme Court I don't want to say shines, but that's where they're comfortable as a deliberative body that moves at a tortoise-like pace. They don't like these emergencies applications, although they are granting them. So if you got rid of this, then you got to go through a dozen or more on the same exact issue. This is where the Bill of Peace keep coming up, which was a predecessor to the class action model, which said that and it was usually used in church groups, if a whole bunch of parishioners had a problem with like the pastor, and they would do it through a Bill of Peace, literally, to try to resolve that dispute. Right? The same issue coming up over and over again, being resolved in one matter, in one dispute. That's what they keep referring to. We don't use those anymore. Those came out of old-timey times. We moved into Rule 23, which was passed by Congress, which is a class action. Now, what didn't come up, and if I was when you make I've done oral advocacy at appellate courts, just not at the Supreme Court, and there's always two oral arguments. It's the one that you wish you made. and then there's the one that you actually made. And sometimes they line up. You're like, that's exactly what I wanted to do. And there's other things like, crap, I left out 3 points I wanted to make. One point I didn't think they hit hard enough is that temporary universal injunctions have been used going back, I think Sotomayor touched on this point, up to 100 years. And most of the most major decisions at the United States Supreme Court, desegregation, school desegregation, civil rights, busing, came up through a version of a nationwide injunction that needed to be resolved by them. So they generally like that process. And what's the harm? Because you saw, and I thought the other point that wasn't raised, is that when Judge Boasberg in the Alien Enemies Act case quickly certified a class of 250 similarly situated Venezuelans who in the middle of the night were put on a plane and sent to El Salvador, they objected to the certification of the class because, as was pointed out by Ketanji Brown Jackson and by Kagan and Sotomayor, why would you ever bring the substantive issue up to the Supreme Court if you can just avoid injunctions and just leave it out there for as long as possible, maybe your entirety of your administration, to implement your policy, and you don't want it to be ultimately decided by the United States Supreme Court? That's the catch me if you can analysis, right? And so let's do the value add here. What do you think the ultimate vote is? And then we'll go back and pick up some of the language that was used to explain it.
I mean, I can see them honestly just not going into whether or not nationwide injunctions should exist. I mean, the question really before them is, should they stay the underlying injunction or not? I think they stay it. I think the merits allow them to stay at basically keeping the status quo. And they might decide as little as that, because like I said, I think this is not a great case for them to change it. And Sawyer certainly didn't present a good alternative. He presented like a chaotic mess. Unless the Supreme Court rules at the end of the day, this is about the Supreme Court wants efficiency, legal efficiency. Even in the lower courts, we don't have enough judges for even normal cases to proceed. What Sawyer presented was like chaos, legal chaos. That's not a good alternative. If he had come up with a workable standard, Supreme Court always wants a workable standard, maybe, but he did not. And I have to say, we do class actions all the time, right, in our law firm. So for me, the thing that I heard is that Trump is wanting a class action because he wants to make it difficult for people to protect their rights. Because one, now they are going to argue that people should not be part of the class and it should be not certified. So that's a whole other hurdle. The other thing that didn't get addressed, but frankly, I think this is something that they have thought about, is that any attorney in the country can go and file a class action. And under our rules, the first filed is the one that proceeds. So do we really think that a pro-Trump lawyer is going to file first and against the executive order and try to certify the class? I mean, this is what you're dealing with, right? You're going to have, an attorney who's really probably not wanting to overturn that executive order try to file a class action.
It incentivizes bad behavior.
It incentivizes bad behavior. And I think that the state, the New Jersey, and both, it's interesting because both of the people that argued said, for class action didn't address their problem. And maybe we'll get into the buckets now, right? They had these 3 buckets because I know everyone's like,
kick the bucket. I wanted to kick the bucket.
Let's go to the bucket because the bucket was one, the alternative remedy was not workable, right? And so for that worked for the states because you can have a class action for the states. It worked for the nonprofits because yes, maybe their members could be part of a class, but their organizations couldn't be part of a class. And then the second bucket was whether or not there was congressional action. And then the third bucket was it so important that you needed to do this expeditiously, which this applied, right? Because we're dealing with people's citizenship. But I thought that like all the arguments about the class action was also really bad when you're dealing with two, the states and these non-organizations. It doesn't address it. So again, I think that this is a losing argument for the nationwide injunctions because they did not present even anything close to a workable standard. It would require the Supreme Court justices like Alito and Thomas on their own to come up with a standard. And that's not usually how the Supreme Court works. They usually do try to do it based on something presented to them.
Yeah. I think we're going to get I think the reason they took the case and the reason it went for so long is that they're going to give the lower courts guidance about when and how to use nationwide injunctions. I don't think they take it out of the tool bag. I think what they have been struggling with and what will satisfy even some of the right wing, like Gorsuch, is if they give proper guidance, a factor analysis, a test, which has been sorely lacking in the area of nationwide injunctions. And in doing so, they will trim the sail a bit about how it's used, I am sure, in order to get a consensus vote. I think nationwide injunctions survive. I think it does so with, I don't know about the vote. I don't know if it's 6-3 or 5-4 or 7-2 or whatever it's going to be, but it's not going to be, it's not going to be 9-0. I'll tell you that. They won't touch the merits. They may use the merits of the birthright citizenship as an example of why nationwide injunctions should exist. Because as you said, it's a terrible case for the Trump administration to have been pushing for nationwide injunctions to be decided on this case. I asked Ben Meiselas, my podcast partner, on Saturdays, I said, why do you think this is the Trump administration taking this appeal? I said, they're on a losing streak at the Supreme Court. 3 separate cases in a row, one worse than the other on immigration policy, which is similar to this birthright citizenship issue. Epic losing streak below at federal courts. Why would they use birthright citizenship as the vehicle to argue against nationwide injunctions? And he said it's all political. He was very there's no good reason from a legal strategy standpoint. It's just political. He just wants to, shake the tambourine for his base, and that, I'll check another list, something off the list. I went after birthright citizenship and nationwide injunctions, but it's a terrible case from a strategy standpoint. That's why I think you found Sauer so disjointed in his argument. I mean, his rebuttal was terrible. Let me just talk about it as an advocate. When I'm listening and I got a 2-minute rebuttal, right? You can't rebut everything. And he had 2 advocates he was going up against, right? One from Georgetown University, Corcoran, who's the head of their constitutional law thing, who was arguing on behalf of groups and amicus briefs, and then the New Jersey Attorney General. So he had 2. So you can't do that. So you take out a piece of paper and you try to come up with the 1 or 2 or 3 points where maybe you were hurt or that you need clarification on. He led with, and that's what you go up with, like a Sharpie pen, and you go up to the podium really quickly, and you have your 2 or 3 minutes, whatever it is. He led off with slavery again, which is first of all, it's on the merits, so it's the wrong place to be. He wasn't hurt on slavery during the argument. So why are you because he's trying to find a life preserver, because he knows he did not do well during that argument because he couldn't answer fundamental questions. I mean, there's clips out there, we'll cover them on Midas and on Legal AF, where he can't even answer the question about, well, how will this, and this was from softballs. This was from people, in his own wheelhouse. how are you going to actually implement this on let's just use birthright citizenship. How is that going to work? Well, federal officers. Well, no, I hear you. But how does it actually work in real life? Well, federal officers will have to figure it out. And even the right wing was like, that's not an answer. And then Amy Coney Barrett, she comes in with, let me understand this. Are you going to respect the Supreme Court's ultimate ruling or not? Is that your administration's position or a historic position? And he sort of fumbled on that. Well, what about the Second Circuit? If the Second Circuit makes a ruling and you're in the Second Circuit, are you going to abide by it or not? And even then he said, well, we would generally, but not in all circumstances. I could imagine a scenario like enough. So you're not going to follow precedent, which only supports the argument as why you need nationwide injunction in order to get it teed up to the Supreme Court to make the only ruling apparently that he's going to respect. I mean, that's when the administration is not trying to arrest United States Supreme Court justices and suspend the Constitution in martial law, right? We didn't even touch on that today. I think there's going to be consensus that they can count to 5. On keeping nationwide injunctions in place on certain circumstances and giving them factors. Speaking of factors, everybody said, why are we talking about winter in May? What's the winter factors? It's easy. It's 4 factors about an injunction. We shorthand it at federal court. Sometimes we call it the winter factors. It's irreparable harm, likelihood of success on the merits, public interest tips in your favor, and inadequate remedy in law. And so you have, and 2 of those drive most of the injunction consideration at a court. You are likely to prevail on the merits at the end of your case. They take a peek under the hood at your case. And at the early part of the case, if they think you're going to be the winner, not the loser, that's in your favor. And then irreparable harm, which is what it sounds like. No money can compensate you. You will lose. You'll be a citizenless baby with nobody. Well, your parents will be deported to El Salvador. You will be left in an orphanage that you'll have to pay for yourself, and nobody will take you in because your parents' country doesn't want you because you weren't born there. Because most countries have some sort of version of you're born on soil, you are a citizen. And so what do you do? So that is the very definition of irreparable harm. So that's the winner factors. We talked about buckets, and did we go over percolation?
We didn't, and I'm going to jump into about Article 3 because that came up a bunch.
Article 3.
That came up a bunch, and that had to do with that final exchange between Justice Ketanji Brown Jackson and the Corkin attorney, which seemed antagonistic, but like you said, she was trying to draw it out because what Sawyer was saying that like under Article 3, judges are only supposed to decide the merits of the case for the parties in front of them. And so nationwide injunctions is in excess of their constitutional authority, right? That was his essential argument. And Justice Ketanji Brown Jackson, during her questioning of him, first brought out her idea. Well, isn't it consistent with Article 3? Because here in this situation, the judge is just saying that this executive order changing the constitutional definition of citizenship is unlawful. And that if people are benefiting from that like statement under this injunction, then it is almost like a collateral benefit, right? Because Justice Roberts had brought up the idea of a collateral benefit in terms of gerrymandering or in terms of discrimination injunctions that maybe the state there is saying this is unlawful and it's, yes, benefiting everyone. And Sawyer was like, well, that's collateral. And so she's kind of brought that back to him and said, isn't that the same thing here? They're just saying that this is unconstitutional. So that was a very strong point, I thought, because it kind of neutered his argument that this was and again, in this particular case in particular, that this was an overreach. This is not an overreach, she said. They're just saying it's unlawful and it just happens to be benefiting everybody. So when the last attorney came in, she was trying to draw that out again by saying, somebody can't go in and enforce, right, the injunction like a judgment because they're not, it's similar, that it's because they can't, it's a collateral benefit, right? Not that they are suddenly parties to the court. That just happens to be a collateral benefit. So that's why she kind of brought that in. Again, that was her way of not having to, for them to uphold nationwide injunctions, but not have to broaden the, let's say, definition of Article 3 judicial power. Her point was that this is within what's already given to them.
Yeah, absolutely. That's why I think at the end of the day, they're going to give it. I don't think they took a 2.5-hour oral argument and took this. They didn't have to grant cert and have this oral argument today or take this up. And I don't think they took it up in order to narrowly decide it and kick the bucket, no pun intended, down the road on the issues. I don't. I think they're going to give, and I think this has been a battle internal to the Supreme Court about nationwide injunctions, and they are going to finally, once and for all, give some marching orders to federal courts. I just think it's going to survive. Then we got to get to the merits. Now, the good news is that there is a nationwide injunction in place 4 different ways by 4 different judges, Maryland, Washington State, I'm leaving out the other 2. I want to say Massachusetts, and the third on birthright citizenship. And that's why every baby that's been born since Donald Trump's first day in office on January 20th, when he signed birthright citizenship as an executive order, is a U.S. citizen. And even his own executive order says it's not retrospective. So I guess that's good. But there's an entire group of very nervous pregnant women in this country, right? And that's the thing that the Supreme Court always pisses me off. They never recognize the real life consequences of their actions. You know, Alito even has said in prior decisions, like about Dobbs, the Dobbs decision taking away a woman's right to choose. Well, what really goes on in public is none of our concern. Really? That's what planet are you not living on that you don't think that's your job is to be the lawmaker, the lawgiver, if you will, at the United States Supreme Court. So that's what I think is going to happen there. On the, it was interesting because, we had you and I do a show called Unprecedented on here on the Legal AF YouTube channel. Take a moment, hit the subscribe button. We could use your help. And we have a Legal AF Substack as well. But we talked this week about 4 different speeches and interviews by the Supreme Court justices, Roberts, Sotomayor, and Ketanji Brown Jackson, leading into today. I mean, they were given speeches maybe because they weren't planning to take this oral argument this late. And I think usually May is April is usually the last of the oral arguments, but they got delayed and these interviews were set before. I mean, May 1st, Law Day, is May Day. I mean, you can't change it off the calendar. So I don't think they thought they were going to give these speeches and interviews during the term, but they have. And I was wondering how that would play out. Look, Sotomayor came out of the box hot. I mean, and just framed the entire debate from day one. And then she was so hot. And I love this part because I do it. She cut off the advocate about 4 times, and you heard a meek Chief Justice Roberts said, "Could I hear the end of the answer on that one?" And she's like, "No. Now let's get back to what I was," because she's advocating, right? Yeah. Because she's trying to frame the argument. You've got Thomas. His verbal tick is, "Let's talk about bills of peace," and then Kavanaugh and Amy Coney Barrett are having a debate about class actions, right? Gorsuch is having a debate about injunctions and buckets, right? And Kagan and Sotomayor and Ketanji Brown Jackson are like leading this argument. Now the question is, will they be persuasive behind the wood paneling when they start doing their caucus and voting? Like, where are we, everybody? And then from there, the circulation of opinions. A lot of people in the chat were like, why aren't they ruling like today? They're not ruling today. We'll get a ruling over the summer. It's going to be 30, 40, 50 pages long. There's going to be concurrences and dissents. They all have to be written as well. They need to be circulated in draft. They're trying to get votes, or votes over to them. Sometimes something that starts as a dissent ends up the majority opinion. Because there's I think that they're making a good point there, or I can't agree with I can agree with these 2 points, but not with these 3 points. I mean, there's a whole thing here. and they want to go on vacation. So it's going to be a minute. In the meantime, like I said, babies born are you?
They're going to percolate. They're going to percolate.
It's a lot of percolating. And we like percolation and marination and deliberation. What we don't like is what we've been watching, which is 13 emergency applications where they breathlessly issue one paragraph with no oral argument and no complete record. And we're stuck for a long period of time trying to, daven over what do these words mean. And trial courts don't like it either because they're like, what do I do with this? This decision on JGG, which is one paragraph, and give it a song. Give me a full, I may not agree with it, but give me like a 40, 50 page opinion that I can make heads or tails out of if I'm a federal judge or an advocate. And so that's the good part about what we just watched. We want this to be their process.
I think that,
go ahead.
Oh, sorry, I didn't mean to jump in. Sawyer was just, he was so inconsistent. It's not good to be inconsistent in your argument with the Supreme Court because his obsession with percolate was basically saying that when you get a nationwide injunction before the full arguments of the case, then you might have like some sort of harm done to you, which in a way is, a valid point. But a few justices brought up the fact of they did not ask the Supreme Court to look at the merits of this case. So on the one hand, they're saying this underlying case is being decided without being looked at the merits. There's no percolation. And then on the other hand, they didn't ask the Supreme Court to percolate on the issue, right? Because they don't want babies born in this country with citizenship document, and delaying that and making it more difficult is the goal. If they really cared about a fully fleshed out, percolated discussion, they had the opportunity. They could have done it at the Supreme Court today if they'd asked them to. And that's not good to be so inconsistent in front of the Supreme Court. And I think that they picked up on that, the justices.
Yeah. First of all, compliment to the audience. Some of you have been on here with us on this marathon. I feel like I'm doing a telethon, like the old Jerry Lewis Labor Day telethon. We're 3 hours into, let's go to the tote board. I really appreciate everybody being, I know people come and go, but
this is like our Super Bowl or a smaller version of it.
We had like 11,000 people at the height. We got 8,000 people still with us here. This is an extended marathon episode of Unprecedented here on Legal AF. If you like what you're watching, then it's easy. It's free. Hit the subscribe button. Help us continue to grow our channel. We're trying to get to 700,000 before May is over. We got a Legal AF Substack, which has amazing content on it you haven't seen anywhere before. I do a morning briefing called Morning AF. We post things like documents filed in courts under Filings AF, which seems to be very popular on the channel. People write for the channel. I write for the channel. It's a great place. It's a great community that we're building over on Legal AF, the Substack. And then right after this, another way to support our content and what we're doing. Yesterday, I did, along with Alex Aronson of Court Accountability and Action, a really fun but insightful and educational interview with Professor Leah Littman, who is at University of Michigan. She's also a podcaster herself, has an amazing podcast about constitutional law called Strict Scrutiny. And she has a brand new book out, which I read and we talked at length about, called Lawless, which is out. And I recommend it to everybody in our audience. People sometimes ask me, Popok, can you be like Oprah and tell us what books to read? Yes, read Lawless by Leah Littman. And we have an interview coming right after this, an interview with her. She is delightful in every way, shape, and form when it comes to constitutional analysis and her book's premise. We then talk about what we thought we would see today. We did it last night. So I think it's very, very timely. So if you're kind of geeked up and geeked out about all things Supreme Court, don't miss this interview that's coming up right next. I think Salty, our producer, has it up as soon as I say, so long to the Midas Mighty, the Legal AFers. I really do. But I really do, from the bottom of Dina Mai's heart, the fact that you guys are here with us, appreciate it. We beat PBS. We beat the live feed for the Supreme Court official. We beat everything. And there's going to be more. I mean, officially, that was the last oral argument and the first oral argument about a Trump policy. It's hard to believe, but there's going to be something over the summer on an emergency application that they're going to want to hear an oral argument on, I believe. And so we may be back in the summer with an oral argument, which is quite unusual. Otherwise, we're back first Monday in October is the new term. What Dina and I will report on religiously, no pun intended, about the Supreme Court is we're waiting on 30 to 35 decisions, opinions to come out. They normally would be out already, but they've been backlogged by the 13 emergency applications. So every day we're going to get 2 and 3 and 4 opinions, and we're going to have to jump on hot takes and on unprecedented to unpack them all. And they are meaningful. There were some amazing oral arguments this year about things that matter at the intersection of law, politics, and the Supreme Court. So you're not going to want to miss that. Hit the subscribe button, hit the reminders. You'll know when we post things. Dina, last word.
Catch me if you can. I think that is the theme of the Trump regime so far. And Ketanji Brown Jackson, she brought it. As you said, Sotomayor, I think, was the lion of today. But Ketanji Brown Jackson, as always, goes to the heart of the matter.
Right. And thank you for being here, everybody. Shout out to the Midas Mighty and the Legal AFers. On to the interview with Professor Leah Littman. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.